You're now live.
Okay, committee. Other than deciding on the weights versus the equity payments and whatever education decides to do with the ELL, either weights, that will come down to us. The other thing we've got to decide is are we going to do a transition program? And what's it going to look like? Traditionally, when there's been big swings in grand lists, when, we have stepped things up or down over usually 3 years. 5 years has been suggested, because I think we want to give schools time to adjust. I think we know if they get a huge bonus right now, they aren't going to be able to run out and hire 3 or 4 new teachers, just given the employment market that we've got. And they'll need to set up programs and whatever. And we need to also transition the towns that are going to see a loss out of this. That's harder to deal with. It'll be harder to pass your budgets when your budget's going up, or your tax rate's going up and your kids are getting less. I think the last time we did anything this large was Act 60. And we did, and the merger bills, and we did transition and incentives and stuff for that. So, Catherine, Brad, any thoughts? I mean, I think we're still trying to get our heads around the tables and figure out who are the winners, who are the losers, how many of them are in each category. And then take a look at the whole thing. So I don't know, is there some help you can give us at this point? Anything you've looked at?
You hit the nail on the head, Madam Chair. It's difficult to see it. Again, for the record, Brad James, Agency of Education. I was just trying to compare how tax rates are really changing. And most of the tax rate swings are not huge, but there are some good sized ones. And I think those are the ones that we need to pay attention to. You don't have this because I just did it. But if we're looking at the all weight, because we have to pick one that we're looking at here. So, we talked about that when I was on a few minutes ago. If we're looking at the all weighting model, most of the districts have tax rates that are fairly small, ranging from 0.02 of a cent plus or minus to maybe 0.5 cent plus minus. I shouldn't say most of them. I say probably approaching half, or at least a third, I guess I should say. So, I mean, it's not going to. This change is not going to have a huge impact on people. People aren't going to be happy with 5 cent increase by any means, or decrease. Well, they would be with a decrease. There are people here who have tax rate changes of 6, 7, 8 cents, 18 cents. So some get pretty high pretty quickly. I think those are the ones that we need to look at. I think, as you suggested and mentioned in Act 60, when that first passed, because that's when I first came on, that was a 3-year transition. The districts whose tax rates went down immediately. And there's money that came into the ed fund at that point that I don't recall what it's from, but there's money that came in. And then those districts whose tax rates were going up to the $1.10 at that point for the base, they had a 3-year transition period. I don't recall off the top of my head how that worked, but it was a 3-year transition period. Then when we did Act 46 recently, a lot of, when you're coming up with a unified rate for a unified school district, that means they're going to be, it's basically a weighted average tax rate is what you're coming to. Some people going up, some people are going down. You put a limiter on that one. I probably suggested it, but you put a limiter on that one saying that people's tax rates couldn't change by more than plus or minus 5% a year until they got to the unified rate, at which point they were there. I mean, they stayed there regardless of what it did. So you have done things like this in the past. One of the things that the task force was recommending was that you look at a rolling average of equalized pupils, and the number that suggests was a 5-year rolling average. So for FY24, which would be the first year of implementation of this, what would happen is the equalized pupil count for FY20, 21, 22, and 23, plus whatever the FY24 equalized pupil count actually is, those 5 numbers would then be averaged, and that would be the equalized pupil count used for FY24. In FY25, you do the same thing. The only question I have then would be, would you use that average FY24 count or the actual FY24 count? That's a policy question. I have not modeled any of this out. I keep thinking, how would I do it? I'm not sure. I guess what I could do is go backwards and take a bunch of districts, but even that's not going to work well. What I think what's going to happen if you do that, because what you're doing is you're picking up new data and get an additional year of new data, losing a year of old data each year you're going out. I think what you would see for those districts who are going down quickly, I think you'd see a curve that start to go like this and start to get a little bit steeper as we got out to the 4 and 5 years is what I think would happen. Assuming the trends of population declines continue. Who knows? I mean, there may be an influx of people coming in because of the pandemic. I don't know for sure.
We haven't seen it yet.
No, we haven't. It's, I don't know if they're, if they're coming in, I don't know if they're being homeschooled, but it doesn't seem to be showing up.
I've got a niece whose children have been living in Vermont and going to school in Boston for 2 years.
Yeah. So anyway, I don't, the pandemic is throwing everything into a loop, but you all know that. I don't need to tell you that. So that's what I think is probably going to happen for a lot of districts. I think it's going to be a steeper curve a little bit towards the end when you get to new things as compared to where they would be. But I think that's a reasonable way of going about it. Again, by the same token, you could also average tax rates or put a limiter on saying you can't change by more than X. But that gets harder because spending decisions change because of demographics that they have. It intuitively to me it does make more. I didn't think this at first, but intuitively to me it does make more sense to go with if you're going to go with a rolling average of equalized pupils as opposed to tax rates.
Okay.
So that's kind of where I'm thinking at the moment. Again, as I said, I haven't modeled this and I haven't figured out how to model this, but I'll keep thinking about it.
Questions at this point, committee? Senator Bray, have you got a question or? No. Okay. Catherine, have you got anything that can help us?
Well, I had sort of the bigger picture discussion to sort of put it on the table. And it's a document similar to what I gave to the task force, just walking through the big picture. And Brad's correct, he went to the solution, but if I might just take a step back, if that's helpful. And I actually had one correction, which I just sent to Faith.
Okay, because yours are not up here yet.
But I can share my document.
That would be good.
And it is just document transition. Here we go. And can you all see this?
Might make it a little larger. That's good.
And yeah, Senator Hardy, does this make sense to go through this? That's what I was thinking, because you were
Yeah, I think it makes sense. Thanks, Catherine.
Okay. Sure. So this was things to consider while you're thinking about transitions. And the top part of this page are the pieces that the task force was explicitly asked to look at. They were asked to look at transition issues, how to transition weights and categorical aid to promote equity and ease of financial impact. They were also looking at the homestead tax rate mitigation, ways to impact the residential property tax rates and consider tax equity between school districts. They were also specifically asked to speak to the excess spending threshold, which whether to retain or repeal. And then there's the hold harmless provision, where you've got in current law 3.5% hold harmless provision, where you can only lose a certain number of kids per year. And so thinking about the big picture, the considerations that you might consider are, for example, the one is the transition period, how big, and Brad touched on some of this. The Act 46 were 4 to 5 years. I think the Act 173, Brad, you can correct, but I believe those are also 4 to 5 years, 5. Okay. And then the Act 60, I agree with Brad. It was, there is a funny thing about when you implement a bill the first year. We had under Act 60, there was a thermostat for a year, and then we went to the Act 60. So you have to figure out what year you're talking about. But we did have, it was really a 3-year transition once you got over that implementation year. And so those are just things to think about. Do you want to do 3 years? Do you want to do 5 years? That's you don't have to pick those, but those are sort of the typical ranges that you've had in the past. And in terms of the homestead tax rate mitigation, who do you want to mitigate? Districts with increasing rates is one obvious choice. Districts with decreasing rates, depending on your funding, you may want to let districts the rates drop as quickly as possible, but you may also be transitioning in funding. So you may phase both in. That's an option. And you could, for example, put in tax rates can only change. And this is where you would want to get into a discussion about what's the easiest way, but you could do 5 cents or 5%. I believe in Act 60, Brad, maybe you don't, I don't know if you remember, but I think it was because it was a tax rate going to $1.10. So I think there was a phase in maybe a third of the way is how I'm remembering it, up to $1.10. So you did a third each year. So depending on where you started from, you spread that transition over 3 years.
Some of those were like 28 cents to $1.10. There were some big spreads.
There was, I think there was even one at maybe at 5 or 7 cents that had to go up quite a bit. So those are big changes. If you go to if you use the weights, do you use a rolling average? I think that was what Brad was just talking about. If you move to the cost equity, you can phase it in somehow. You could do the same thing where you do, I don't know, 20% a year. You could do that. I think it would be helpful for you all to figure out what you're doing first, and then we could work through the specifics of the options. It's also helpful to think about if you have what is sort of the cutoff, where do you want to transition people? What is enough disruption that you want to mitigate it, and what is okay to let go without any mitigation? And then the ed fund surplus. It's an option that you have to use with the mitigation. When Act 60 passed, the sales tax was increased.
That's right. We went to 6%.
And so that there were funds for that. Right now you have 89, well, as of December, I guess we'll figure out once budgets are set, but right now we estimate to have almost $90 million in the ed fund reserve. So you could direct those funds to be used, or a portion of those funds to be used to help with the transition. One nice thing about it is those are one-time funds, and this would be a one-time use for transition. So that's a nice connection there. I think there will also be some interest in using some of the surplus or the unreserved unallocated ed fund surplus for do you use it against the yield also? That those are discussions that you all will be having as you move through it. So I have also heard of other interest in using these funds for tech center work or for school construction. There are a lot of possible options, and I have a feeling that you won't be able to meet everybody's needs with these, but it's something to think about as you move forward. And the question is, how do you, once again, spread it over however many years? The excess spending threshold, depending on what formula you pick, you may need to recalibrate it, depending on, well, you will need to recalibrate if spending per pupil changes, but you also, do you want to keep the excess spending threshold during the transition period, or suspend it, or put in something to provide some sort of threshold, but have it higher? That will be a policy discussion for you all. And then the final piece was the 3.5 hold harmless provision. It's we put into a provision that we weren't, the ADM pupil count wouldn't drop. So that's not happened this year. But the question is, you may or may not want to have this in place for the future, depending on what formula you go to and what you and how long you transition it for. I would just suggest, I think some of what Brad touched on is important. Like you need, what is a big enough change that you want to mitigate it or transition it? Is 5 cents the right number? Is a certain percent the right number? And once you get a sense about some of the bigger changes, that may give you some insight into whether you would want to do 3 years or 5 years, or more or less than that. But that might help with that decision making also, when you have a sense of which way you're going and who's impacted.
Well, I think up until we got these printouts, we were looking at going to weights for everything other than ELL, and we were waiting for the education committee to send us their decision on ELL. And so, but that can make a big difference. But I thought we were working towards weight. We were leaning towards weights. I think maybe we need to go home and look at the impacts on the charts and see that. And then we probably need to go out and listen to the superintendents again about what they feel would be manageable in terms of change. I'm sure everybody would like to get, it's my money and I want it now. And I think we might be a little more hesitant with that if we didn't have a surplus, but we do. And so we have some ability to cushion the transition. There are other needs I didn't realize, but in the budget last year, we required all schools to do an air quality test. And that picks up PCPs, which could be, as Burlington found out, extremely expensive to fix. And so I think we can assume, given the age of our schools, that we're going to find some need there, which we can deal with in other ways, but we might want to have a cushion for that one too. But I guess it depends. Yeah, we've got a bunch of schools that are going to see a small transition, and we can probably do that in a short frame, or just say, swallow it, whatever. But we've got some schools that are going to see some big swings, and we should probably talk to those schools and see if their superintendents will come talk to us and get a sense as to how they might handle that. And I think we'll put out a call for next week for some superintendents to talk about how these swings would impact their districts and how they might handle a swing up or down. Senator Bray.
Thanks, Madam Chair. Your mention of PCBs in school
Yes,
reminds me that we also were doing surveys and trying to remediate lead in school as well as
Yes.
PFAS exposures. So I don't know how many of these have accumulated and where we are in assisting schools in taking care of all of them, but
we aren't.
wanted to remind ourselves that there's at least 3 sort of distinct categories of unhealthy things that we're trying to get out of our schools.
Right. And that will cost money. And so, and once we know, we're liable. So I think we can anticipate there will be a need either on the local tax rate or on the state to somehow come up with some money. Because there's no way we're coming up 100% clean. So that's just something to keep in the back of our minds when we're spending surpluses. And again, we don't know how long the spending spree is going to go on that's been really pumping money into the ed fund. But the projections are it's going to level off pretty quickly. Senator Hardy.
Thank you, Madam Chair. Just a couple things I wanted. Catherine's presentation was the same that she gave to the task force, and we had basically an entire day where we talked about transition and had a lot of superintendents and other people in to talk about transition. And generally speaking, most people favored a 5-year transition that was similar to this roll-in of Act 46, which basically people complained about Act 46, but they didn't complain about the 5-year roll-in. So that was sort of an indication that the roll-in was one of the things that people felt okay about. We also heard pretty clearly from people that the suspension of the spending threshold would be really important during the transition period, because there would be districts that would be losing equalized pupils and having their spending go up beyond their control because of the loss of sort of equalized pupils, not because they actually increased their budgets. So I did want to just let you know that tomorrow, and I can give you a preview before we go over the draft, or I can go over it. I can give you a preview now, but a lot of this stuff is in the draft already tomorrow, because what I had Jim draft was basically the recommendations in a lot of areas that the task force came up with, including transition. So what is drafted is a 5-year transition of 5-year average equalized pupil rolling average, like Brad suggested, for the first 3 years. Then it would drop to a 4-year average, then a 3-year average, and then continue with a 3-year average sort of indefinitely. So that there wouldn't be a drop at the other end of the 5 years. So that's what's drafted right now. And it was sort of a smooth up and then smooth down, and a suspension of the threshold and a suspension of the hold harmless. Brad and I went back and forth on this about what to do with the hold harmless. And I ended up suspending the hold harmless because it creates a sort of false drop and then goes away. So I suspended it in the draft. Now, obviously all this can change, but I wanted to draft something for people to look at so you can sort of see what it is in there. I can't remember what other transition things, but that was there. I didn't put anything in about the spending of the
Yeah, well, I mean,
surplus,
we can decide what to do with it. Then we got to decide where to get the money.
Yeah, the surplus. I mean, I think what Catherine said just really quickly. You said it quickly, but I noted it. You can do it with the yield too. You can change
play
your
with that,
playing with the yield, and so that might be a subtler way to do it once we see budgets coming in where we need to set the yield. But just wanted you to know the draft is 32 pages long, so there's a lot in there.
Okay. Gonna have another fun day tomorrow.
Yeah.
So committee, just think about this. This one, we're going to have to get out. I mean, the public expectation is there, a lot of pressure. So this one's got to come out in the next probably 2 weeks. Then the House will do its thing, and then we'll go to conference. And we'll see where that goes. So questions at this point, and Brad and Catherine, I'm not sure how much modeling or just research you can do. I know we've got all kinds of folks picking up the property tax and the ed fund for us, but any thoughts about how we could transition? And I'm not, the yield has always thrown me. Tax rates, I understand. But how adjusting the yield could also be used as a way to transition this one in. And we'll see where that goes. Senator Pearson.
Would we anticipate sort of a fast transition up and a slow transition down, or is that, I mean, Senator Hardy, when you said 5 years, those were the people that were on the painful end. And I'm sure, do you mean that it was sort of in a parallel, or the people that have a correction that helps them spend more money? I'm assuming they were not so patient.
Everyone we heard from was, and I can't remember everybody's testimony, so don't hold me to we heard from literally hundreds of people, but everyone seemed fine with a transition of some kind, not like a boom right away. And averaging equalized, and Senator Brock is nodding as well, so that's your recollection. Averaging the equalized pupils seems like a logical thing to do, because what we're talking about is changing equalized pupils by changing the weighting of those pupils. And so it would bring it in slower for everybody. And if you do the people going, if you don't do it the same, it's going to cost a lot more money in the ed fund to go up and then not go down, or vice versa. And it makes it a lot more complicated, but I defer to Brad on that. But the way it's drafted right now is everybody would roll in, whether they're going up and down or staying the same. But certainly we can talk about how we could do it the other way. But everybody we talked to was, as long as we suspend the threshold, that was a big thing, was
Okay.
this transition over 5 years, or 3 to 5 years, which I sort of split the difference by rolling it up and then down.
So maybe if joint fiscal could just help us do it, we may want to do like, I know the folks that are getting more would like it, but just getting a huge lump is also, as we're finding out, hard to deal with, and doesn't necessarily lead to the best planning. So maybe we could phase the folks that tax rates are going down, or whose money are getting more money, in over 2 to 3 years, and then do other people that are going up a certain percent. But then I think there's a couple of really big losers, and we might want to look at phasing them in over 5 years. I mean, we don't have to do everything the same. If you're just doing a small increase, and we could say, and if you're less than a penny, we'll phase it in over 2 years, kind of thing. But if you're seeing a 15-cent increase, that we're going to phase in over 5 years.
Can I just add one thing to answer Chris or Senator Pearson's question? Is The other thing that was a consideration was some of the districts that would gain tax capacity and benefit also are the districts that have the most ESSER funds, because the ESSER funds themselves are weighted in a way because they're based on the Title I formula, which is weighted toward districts with more students in poverty. So that also was a consideration, that the phase-in would actually happen when the ESSER funds are spent down, is when they would get the biggest bump on the way up. Does that make sense? And so it would help them sort of, as Senator Cummings said, that planning for and relieve the drop in ESSER funds. So that was another consideration we talked about.
Okay. I think that's it. Senator McDonald, you look pained. I'm not sure if you're having a heart attack or you want to talk to us.
While we're considering this and the surge of spending that's come in on the sales tax based, we've asked, I think, for the number of people that continued to pay their local education taxes based on their income. And it might be helpful. I'm hoping that we get that report here soon, so we know whether it's 80% as it used to be, or 70% or 65, as we are considering the questions that you've just been asking us to take a look at.
Okay. But even those paying based on their income, they do, if your school spending goes up above the state, you're not held harmless if your school spends more, despite some of but it's a good thing to know. We're going to move on because we have, again, on the agenda, complete switch, S-247, which is genetic information and discrimination. So I thank Catherine and Brad. And this one committee, we've heard from the doctors, we've heard from the insurance companies. I want to see if we can get somebody that does disability insurance. Because life insurance you buy once. I want to see, the other one was long-term care and disability insurance, and see if we can hear from insurance companies that do those and what impact, if they use genetic information, do they change your rates over time based on history, or is it more based on the OSHA ratings of your job? But I'd like to hear those, but I wanted to hear from the committee, your thoughts on this bill. Where are you, where are you going? I've asked, and I haven't seen yet, to see the disclosure that people have to sign before getting genetic testing. Faith may have that, but I'd asked to have that brought over so we can see exactly what risks we are telling people they're taking by getting a genetic test. So Senator Pearson.
Well, Madam Chair, I'm not sure if others agree. So, but it seemed like putting some kind of cap on, this applies for life insurance under whatever, $500,000. I don't know the right limit, but I was hearing that if you put in that limit, a lot of the fear and tension goes away. And I mean, I know all that we've learned in a couple of days of testimony and not much more on this. And that appealed to me because I am intrigued. I think this is, only going to be more relevant. And so that seemed interesting to me. And I don't know if you or others agree.
yeah, I think, my concern is that people shouldn't hesitate to go get a medical test because they might not get insurance. On the other hand, the life insurance, at least, you buy it, the rate set based on your rating, what they know about family history, and that's it. They can't go up or down. If you have the genetic test after, you bought the insurance policy, the risk is that you might go out and buy a $300 million policy and die 3 years later, and that impacts the cost to everybody else. So I think the insurance people did talk about other states setting a limit on, you gotta come in and reveal everything to us. And I don't know that we want to back down on, you have to have, maybe you do. I mean, or at least you can buy $300 billion worth of insurance now without genetic testing. But if you've had it and it's in your medical record, there should be, I don't know, a way to prevent that. Senator Bray.
So I worked at National Life for 4 years, and I was not in the underwriting department, but my understanding is that the higher your policy value goes, the more stringent the underwriting, which makes sense. And so I think, there's some sense to what Senator Pearson is saying. If it's $1 million is a lot to us, but it on a life policy, that may not actually be a major, a particularly large policy. I don't know the current numbers, but back to where you started with on tests, I would want to lean into protecting that information until we could control it, knew how it was going to be used, controlled, spread, et cetera, because once it's out of the barn, I don't think we'll ever corral that information back in again. And so I'd rather be cautious about letting the information out. And if it means you can only get a smaller policy, then it would still be serving its purpose, right? I mean, it's supposed to provide for some sort of helpful financial transition after your death for your heirs, survivors, family, whatever. So,
Damien, have you done any research on what other states do?
Good button. So Florida has, as some of your witnesses mentioned, Florida has a fairly comprehensive law. Arizona, California, and Montana all have some additional protections, and other states, like I mentioned, Connecticut on my first day of testimony, recently enacted something similar to what we already have on the books in Vermont, which is the restrictions around requiring a genetic test.
Right.
But let's just see here. Florida's statute here provides that in the absence of a diagnosis of a condition related to genetic information, health, life, and long-term care insurers may not cancel, limit, or deny coverage or establish differentials in premium rates based on that information. They're also not allowed to require or solicit genetic information, use genetic test results, or consider a person's decisions or actions relating to genetic testing in any manner for insurance purposes. However, and then that section specifically excludes accident-only policies, hospital indemnities, dental policies, vision policies, and policies related to those. And it also specifically provides that it does not prevent a life insurer or long-term care insurer from accessing an individual's medical record through a medical exam, or from considering a medical diagnosis in an individual's medical record, even if that diagnosis was made based on the results of a genetic test. So they can consider the information if there's a diagnosed genetic condition that they find through a medical exam, or if the individual's been diagnosed with a specific medical condition, wholly or in part through the use of a genetic test. What they can't consider is other genetic information that individual may have acquired, or that individual's actions in relating to deciding whether or not to get a genetic test and conditioning their insurance. So their law is similar to
Ours.
what S247 is proposing with a few tweaks. S247 would also permit the consideration of a diagnosed medical condition, but it doesn't allow them to consider a genetic predisposition for developing a medical condition.
They have any limits on the size of policies in Florida?
Not that I'm aware of. So certainly not in that section, but I don't profess to be an expert on Florida's insurance law.
Okay.
Some of the advocates may know otherwise. I do recall, and I think one of the articles that was shared, there are some policy size limits in some of the international jurisdictions that have restrictions. But I cannot remember what those are, or what they were conditioned on.
Okay. So right now, we cannot require a genetic test as a condition of insurance. But if you've had a genetic test and it's in your medical record, or if it's in there, and they can right now they can consider family history. So you've got 3 family members with a specific cancer. They can't require you go have a test to see if you have it, but they can take in the medical history. And again, depending on when in life you buy this life insurance policy, if you buy it fairly early on, there probably isn't time, but at least for your siblings, to develop some conditions. If you buy, but then you're going to get a longer assumed lifespan to pay for it. If you buy it later, you may have more in there, but a shorter span to pay the difference. But right now we can use what's in your medical record. So if you've had a genetic test and it's in your medical record, they can use it. Is that what we're changing?
Yeah, so what we're adding is a provision that says you can't condition insurance rates or you can't condition insurance on the basis of genetic information of an individual that's associated with a potential genetic condition, but that has not resulted in a diagnosed condition of the individual, or on the genetic information of a member of the individual's family. And that's actually an important change too, because
Yes.
genetic information, we're expanding that definition to mean the results of genetic testing or the manifestation of a disease or disorder in a family member. And that is one of the key pieces here is genetic information. We're adding the manifestation of a disease or disorder in a family member. That's one of the key pieces of this bill in terms of what it would do, is that's getting brought under the term genetic information. And then we're
Okay.
saying that in addition to that, what this bill is saying is that you can't condition insurance on genetic information of an individual associated with a potential genetic condition that hasn't actually been diagnosed yet. And then the current law says you can't condition insurance on the results of genetic testing of a member of the individual's family. And we're changing that to genetic information, which includes those diagnosed conditions that have a genetic marker. So,
Okay, so that's a
that-
big one.
yeah,
I've
so those are
got a
the,
mother, an aunt, and a sister who have all been diagnosed with ovarian cancer, which is one that has a genetic marker.
right.
Okay, and right now, that's in my medical record, right? They've,
Right. So you've got that family history of ovarian cancer, which has a genetic predisposition in some cases. And there you've got, 3 family members who have it. And what this is saying is that you wouldn't be able to consider that. There is an important caveat with respect to life insurance contained in Section 3 of the bill, which provides that a life insurance company or its agent can condition insurance rates, the provision or renewal of insurance coverage or benefits, or other conditions on the individual's family medical history, including the manifestation of a disease or disorder in one or more family members, provided that there's a relationship between the family medical history and the cost of the insurance risk that the insurer would assume by issuing the policy. And so that was something that was added in the Health and Welfare Committee's amendment during the last biennium, when the original version of this bill was introduced. And then it was on its way. It had left that committee right before we shut down for COVID.
yeah, it did.
So what this doesn't include, though, is a similar language in the broader unfair methods of competition and unfair insurance practices section, which also arguably applies to life insurers. So there is a little ambiguity in the bill. If you did, that's probably something I would recommend cleaning up. But this is just based on the language that came out of Health and Welfare. And at the time, I don't think any of us caught that issue there, that there were these 2 sections that both apply to life insurers, and one has the carve out and one doesn't. But so life insurers, but not long-term care or disability insurers, can consider an individual's family medical history. They still can't consider the individual's genetic test results or require an individual to undergo genetic testing. So that's kind of where things stand for life insurers. And then long-term care and disability can't consider the family genetic history or the individual's genetic test results or require genetic testing, which is the current law.
Okay, so in no one's ever asked in my long-term care insurance, but my grandmother and great-grandmother lived to be, both of them, 10 days short of 100. But at least my grandmother spent probably the last 10 years in a long-term care facility. So I assume, so life insurance, your rates are based on risk, and the risk that really they want you to live a long time so you can pay off the value of the insurance policy, paying it in. So every time somebody dies sooner than expected, that's a cost that's going to get figured out over and the amount of the thing. So life insurance and it can consider a family history that is in my medical record, right, under this bill.
Yes.
But long-term care can't. I'm not sure where well, I suppose, or disability insurance can't. Okay, Senator Brock.
My understanding, and I may stand to be corrected, Damon, is under the federal law, long-term care insurance can consider genetic information. Health insurance, life insurance, and long-term care insurance, I believe could. Am I correct there?
Yeah, so the Federal Genetic Information Non-Discrimination Act applies to health insurance and employment. It doesn't cover other forms of insurance. So that's where in recent years, states have, in some cases, started regulating the other forms of insurance in terms of genetic discrimination or genetic testing. So Florida is the one that's probably gone the farthest at this point, but other states have limitations on requiring genetic testing or using third-party commercial genetic tests and so forth. But it's the articles that were shared by one of the advocates, I think Faith forwarded that email to the committee a couple days back. Those had a summary of the states that have of some of the different sorts of things that some states have enacted, and certainly not every state has acted in this area here.
Okay.
I know I've read a couple of articles recently, though, that says that a number of insurers are in fact doing genetic tests for long-term care insurance.
Yeah, I couldn't speak to that. That's outside of my area of knowledge for this. So I would recommend hearing from the various advocates on this who know a lot more about what's happening
I think
in practice.
DFR would probably tell us. It may
Yeah.
well be that that's the federal law, but we can be more restrictive.
Right. So, I mean, a lot of, as you know, we regulate insurance at the state level, so we have freedom to regulate in these other areas here where the federal government has chosen not to act at this point.
Well, in general, I'm reading, have been reading an article on the subject I was interested in, and it just simply says here, in general, long-term care insurers can indeed use your genetic test results when they decide whether or not to offer you coverage. The Federal Genetic Information Non-Discrimination Act prohibits health insurers from asking for or using your genetic information to make decisions about whether to sell you health insurance or how much to charge, but those rules don't apply to long-term care, life, or disability insurance.
That's right. The federal law does not apply to long-term care, life, or disability. Our state law currently prohibits requiring a genetic test or using the genetic test results of a family member. It doesn't prohibit using your family member's medical history to, as in Senator Cummings' example with the family history of cancers, or using your own genetic test results. So this bill here would prohibit the use of the individual's genetic test results if there isn't a diagnosed condition, and then also using your family members' medical histories to the extent that shows genetic information for your family.
But in the present, where we are right now, assuming this bill is not enacted, is there any restriction regarding, for example, long-term care disability insurance under Vermont law?
Yes. So right now, under 8 VSA 4724, 4724, I don't know if it's A. No,
We don't-
47,
we
24,
don't either.
22. You can't condition insurance rates, the provision or renewal of insurance coverage or benefits or other conditions of insurance on any requirement that an individual undergo genetic testing or the results of genetic testing of a family member, unless the results are contained in the individual's medical record.
Okay.
So if it's in the individual's medical record right now, you can consider it, but you cannot seek the test results of the family member, and you can't require the individual to get a test.
Thank you.
So, but
Okay.
we are one of only a few states that has that sort of provision in place.
And under this, life insurance you would not be allowed to consider any genetic test results that were in the medical record unless there had been a diagnosis of a disease. But the change Health and Welfare made last year said that life insurance could look at your family history. So whether there was a genetic test or not, if 3 or 4 of your family members had congestive heart failure or, ovarian cancer, whatever, that could be considered if it was in your medical history, that there was a family history, but that's diagnosis. But it did not extend this to long-term care or disability or any other insurance. Is that correct? Okay.
Yep.
That's probably the big change here then, that you can't consider family history even if it's part of your medical record. If it used to be, my sister had a genetic test and it says, she has a proclivity to this, or is likely, that could be considered, and now it can't.
Yeah, so under existing law, if your sister's genetic test was in your medical record, it could be considered. If it's not in your medical record, it can't be. However, if she's got a diagnosed condition, and then that could be part of the record they can consider. So there's sort of the, it's one of those if-then sort of series of boxes where you kind of are going through and you're saying, was there a genetic test? Yes. Is it in your medical record? No, then you can't consider it. Yes, then you can consider it.
Okay. So if your mother and your uncle and your sister had Huntington's disease, then but just that there's a genetic test that says, yeah, you've got it. You've got the gene or the whatever it is. I'm not.
Yeah. So under this bill, that information could be considered by life insurers. The fact that you had 3 family members who had it. But if it was simply that you were tested and you showed up with that genetic marker there as a predisposition for Huntington's, that's not permitted under this bill.
It'd have to be a family diagnosis. Okay.
That's right.
But we did not extend that family diagnosis under this bill.
Yeah, we left it just for life insurers.
Yeah. So if I've got disability insurance and 3 members of my family have come down with ALS, which means I may be disabled, if I fall into that group, I may be disabled for some time. At least until my life insurance picks up. Okay. They can't consider the fact that 3 members of my family have a disease that has caused them to become chronically disabled.
Right. You're talking about disability insurance now?
Yeah.
Yes.
Okay. Okay, Senator Bray.
Senator Brock's question got me thinking, and it's not exactly in this bill, but it's kind of the opposite side of it. Are insurers, I don't know if Mr. Leonard knows or Senator Brock, insurers are offering discounts to people who are willing to go get tests. Have we had to face that thing? It's sort of an interesting thing. Get a discount if you'll be tested.
So right now, the law says it can't be conditioned on an agreement of the individual to undergo genetic testing. And saying if you agree to get a test, we'll give you a discount on your rate. Sounds to me like, and obviously it's not my job to enforce the law, but that sounds like it's potentially falling under that conditioning and insurance rate on an agreement to undergo genetic testing. But that was that's one of the potential issues here to kind of consider. So I know one of your witnesses the other day talked about, well, what if you have a test that shows you don't have the disease? But again, these are sort of policy questions that are in front of the committee. So, but right now, I think any sort of agreement to say, we'll give you a discount if you take that test would probably be prohibited under our existing law already.
Unless the discount continued even despite the results of your test.
Right. Well,
probably not.
I'm sort of glad to hear there'll be a slippery slope if you started offering discounts for tests, and then where will we go from there? I also get the feeling this is we're at such an early stage in all this, that there's a lot more sophistication to be figured out with every year.
So I got Senator Hardy and then Senator Pearson.
Yeah, thank you, Madam Chair. It seems like the whole discount thing, that's kind of coercion, and I'm glad to know that wouldn't be allowed under our current law. I'm wondering, Damien, if since this bill, I think, was passed out of committee and was sort of on the docket on our calendar for a while back in 2020, do you have a summary of it that you could revise and give to us? Just because hearing this conversation, I feel like I understand it and then I don't, which is kind of the theme of this week in committee. If you
this is a simple
summary,
one.
Yeah, I mean, I'm glad. I understand the pupil weighting stuff, so I'm ahead of the game on that one. But but if you had a summary, I would be very appreciative.
Would a summary or would a side by side, the present law and this bill, be more helpful? That would be great. Columns.
Exactly, 2 columns. You could make a flow chart and you could make it color coded, and then the chair and I would be super excited.
And you know how easy that is.
I know it's really hard to make a flow chart. Anyway, thank you. Whatever you have would be fine. Thanks, Damien.
Okay, Senator Pearson.
We've been talking about the prospect for life insurance of your DNA tests and it's sort of being out of bounds. But I'm curious, I would like to understand when people do a 23andMe, as that was called, for instance, I'm pretty sure they're signing away a lot of rights there, and that then companies, insurers, are buying huge banks of this data, and so they're going to cross match and find your sister and blah blah blah. And so I guess I'd like to understand that to me adds some urgency to this kind of proposal, and I would like to make sure that the discussion has been what's in your health record. And could you help me understand whether we're covering these sort of third party people that get access to this information in other ways, or do you see my question, and could you help me understand?
Yeah, so existing law already says that you can't condition insurance coverage or the conditions of insurance on the results of genetic testing of a member of the individual's family, unless those results are in the individual's medical record. So
Okay.
the third-party tests under existing law are already off limits in
Okay.
terms of conditioning health insurance benefits. I'm just paging through the bill quickly here to see if there was anything else that we added on it. I'm sure it'll surprise everyone that I haven't memorized the bill yet. So, yeah, and in looking at the bill, we've already got that protection against the results of genetic testing for an individual's family member, unless it's in the medical record. So I would say that covers the 23andMe or, whatever other sort of private, ancestry or other sort of genetic screening that is out there privately.
Thank you.
Yep.
Okay, so it doesn't matter if you sign, if you have it done for just somebody gives you a test kit for Christmas, seems to be the newest in thing, and causes problems on occasion. They can't use that regardless of if they asked you to do it, or your doctor, or you just did it for the fun of it. They can't use that information.
Yeah.
Okay, committee. It sounds like we may, I don't think we want to go back and tighten. I don't know. The big difference, I think, is that we did, and maybe we need to put it up front, allow life insurance to look at your family history. I get, of illness, which may indicate there's a genetic but but we didn't allow that to the other types of insurance. And that seems to be the one change. And then the question is, do we want to put a cap on how much life insurance you can take out without further medical testing? I would think if I had a life insurance policy for $300,000 and suddenly around the age of 35, I decided I wanted to up that to $300 million, the insurance company might want to say why, especially if I hadn't just won the lottery. So is that something that's on anyone's radar? And maybe we just need to look at the information that Damien has given us on what other states do.
Yeah, I can send you copies of the other states' laws. I'll put that on my list of things
Do
to
you think
compile.
NCSL might have a breakout of that? They seem to do a lot of charts. We could check with them and not have you to redo the.
Yeah, I can reach out to them to see if they have a breakdown on this.
Yeah.
And there may be other witnesses who are listening in on the meeting today.
Yeah, I
who
think
have that
I'm
too.
going to see if we can't we'll try DFR and see if we, get a briefing and see if we can find somebody that represents companies that do disability and long-term care. And have them come talk to us about what they do and what implications there are for them. Does that work? Okay, everybody is getting glassy-eyed. It's been a long, and this is the easiest thing we've done this afternoon, Damien. It has been a heavy afternoon. So I think unless somebody else has, if you think of something you'd like to hear or, have a witness on, let me know, let Faith know, and we'll get a little bit more testimony on this. And then I think we're going to have to make a decision up or down, and we'll get it out of here. Okay. Okay. Thank you, everyone. We can all go now and spend a restful evening reading Brad James's data